Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. Try to help each other with our fighting foreclosures. This is my Facebook page, which is also called Foreclosure Help 777. If you have questions about your foreclosure that you might be going through, you can always join our Facebook group and send me a text or an email. I also have an email address of foreclosurehelp777@gmail.com if you want to send me an email. So let's get started. What we're going to talk about today, a fellow foreclosure fighter has filed a motion to dismiss his case. It's in New York City. William Carrington. We're going to talk about his case today. This is his case number 11234-2009, and you can see from the beginning the complaint was filed on 5/7/09, and it went from there on, and you can see from 2009 all the way to the end here. Let's go to the end here, shall we? Okay, on 12/4/2023 is when he put in for his motion to dismiss, and if you click on this you'll see what that looks like, the motion cover page, and you can see that it got approved by the court. It was stamped, and this is just what it looks like. The motion cover page tells him the date of 1/3/2024, but he found out later that it was rescheduled till the 9th. But anyway, the actual motion is not on file because the judge has it. But let's take a look at the motion that he did file. This is the motion cover page that was filled out. Okay, so when you do a motion to dismiss, you have to have a memorandum of law in support of it. And so this is what the cover page looks like for your memorandum of law. Just has his address and stuff on it. And then the next page is your table of contents. And so for the table of contents, we have a preliminary statement, and then relevant statements of facts and procedural history, and then judicial malfeasance, fraud on the court, plaintiff Wells Fargo should be sanctioned, conclusion, table of authorities, exhibits. Okay, so let's get started. Here's your table of authorities. We're not going to go through each one of them because there's a lot. But they all have to, a lot of them have to do with standing. And these are some good cases. Okay, so let's look at the preliminary statement, okay? Defendant William Carrington, pro se, collectively the defendant, submits this memorandum of law in support of his motion to dismiss pursuant to CPLR 3211A3 to dismiss the complaint with prejudice. Defendant also seeks sanctions pursuant to 22 NYCRR 131.1 against Wells Fargo based on the meritless filing of the complaint and unlawful actions by the plaintiff and their attorneys. And so this basically gives you an overview of the law that we're talking about sanctions for frivolous conduct, which is what we're claiming that the attorneys are acting this way. And we'll get more into that in just a moment. We won't go through this whole thing. Okay, so it talks about frivolous conduct as well here. Okay, so relevant statement of facts and procedural history. The complaint boils down to Wells Fargo's improper attempt to foreclose on the defendant's property. From the beginning, plaintiff violated RPAPL 1304, which requires that at least 90 days before commencing legal action against a borrower, a lender, assignee, or mortgage loan servicer must send written notice to the borrower by certified and regular mail that the loan is in default, provide a list of approved housing agencies that offer free or low-cost counseling. Legal action may be commenced after 90 days if no action is taken to resolve the matter. Defendant never received this 90-day notice before the foreclosure action was filed. RPAPL 1304 notice that plaintiff submitted is dated May 7, 2009, just one day after the foreclosure action was filed. There is no proof of service, and even if there was, where an RPAPL 1304 notice contains factual inaccuracy, dismissal of the corresponding residential foreclosure action is mandatory. And then there's some case law to back that up here. Plaintiff Wells Fargo filed a complaint in mortgage foreclosure against the defendant William Carrington on April 25, 2008 under index number 12840-08. This case was dismissed without prejudice because the plaintiff lacked standing to foreclose. A copy of this order is attached hereto as Exhibit A. Plaintiff filed a second foreclosure complaint on May 6, 2009 under index number 11234-09. Defendant filed an answer and counterclaims on May 27, 2009. Plaintiff filed a reply to defendant's answer and counterclaims on June 5, 2009. Plaintiff failed to obey an order dated 12/2/14 by David Schmidt, which states that the plaintiff is to provide proof of standing by bringing the original promissory note as well as the date the plaintiff acquired it. A copy of this order is attached hereto as Exhibit B. Plaintiff failed to appear for court hearings on October 15, 2015, September 16, 2015. Plaintiff failed to obey an order dated May 5, 2016 by Judge Robin Shears, which states that discovery shall be completed by May 31, 2016. A copy of this order is attached hereto as Exhibit C. On 12/14/17, Judge Nipel dismissed the case without prejudice because the plaintiff failed to appear. A copy of this order is attached hereto as Exhibit D. The case remained dismissed until June 15, 2017, when Judge Nipel issued an order vacating the dismissal. On September 8, 2017, Judge Nipel issued a conditional order of dismissal telling the plaintiff that they have 90 days to either file a note of issue or otherwise proceed by motion of entry of judgment, because plaintiff has unreasonably neglected to prosecute the case for over a year. A copy of this conditional order is attached hereto as Exhibit E. Plaintiff filed a motion for summary judgment on December 11, 2017. Judge Nipel granted the summary judgment motion in favor of the plaintiff on September 10, 2018. The defendant appealed the case on September 5, 2019 under index number 2019-11687. The appellate court agreed with Carrington that the bank lacked standing to foreclose, reversed the decision, vacating the summary judgment on November 8, 2023. I know we talked about this one on a previous video, guys. Now, the next section is called Judicial Malfeasance. Plaintiff Wells Fargo violated New York Real Property Act's laws 1301-3. Basically, that means prohibition of multiple actions. After initiating an action to foreclose a mortgage or recover a mortgage debt, the lender is generally prohibited from bringing additional separate actions related to the same debt without obtaining leave or permission from the court. Court permission for subsequent actions if the lender wishes to initiate another action related to the same mortgage debt after initial action has been filed. Court permission is typically required. This ensures that subsequent actions comply with the one-action rule. From May 6, 2009 to July 6, 2010, there were 2 separate foreclosure complaints on the same docket by the same plaintiff bank, Wells Fargo, and represented by the same attorney's firm, Mark Broyles of Fine, Such and Crane. Now, there's some case law regarding that as well. Anyway, RPAPL 1301-3 provides that while a foreclosure action is pending, no other action shall be commenced or maintained to recover any part of the mortgage debt without leave of the court, which we just explained. And here we go again with more stuff that they messed up on. So, in this part, the CPLR 3126 basically is penalties for refusal to comply with an order to disclose. Talking about discovery, bringing the note to court, proving standing, and them not showing up. Plaintiff failed to answer discovery request by the date of May 31st, 2016, Exhibit C. Therefore, they violated CPLR 3126. On the first foreclosure case number 12840-08, Judge Robert Miller wrote on an order on the date of February 6, which states the following. Plaintiff's motion for a default judgment and for an order of reference is denied. At the time the filing of the complaint, April 25, 2008, plaintiff had no standing as assignment was not executed until April 28, 2008. Backdated assignments are no good. Wells Fargo violated 3126 and NYCPLR 3012BE after it was ordered to bring to court the mortgage note as evidence of debt as well as proof of the date they acquired the note on December 5, 2014. The order, Exhibit B, states the following. So ordered, the matter is adjourned to February 5, 2015 at 9:30 a.m. Plaintiff is instructed to provide proof of possession of the original promissory note as well as the date that the plaintiff came into possession. Defendant is not precluded from making a motion to re-argue before the next return date. Wells Fargo violated 3126 when it failed to appear in court for a status conference, and as a result, Judge Lawrence Nipel ordered the case to be dismissed. The court order dated February 14, 2017, Exhibit D, states the following. A status conference having been scheduled this day and plaintiff having failed to appear, it is hereby ordered that the above captioned matter is dismissed without prejudice, and the county clerk is directed to cancel the notice of pendency. Okay, so let's go down a little bit more. Fraud on the court. Okay, here we go. We're going to get into some interesting stuff here, guys. Option 1 ceased to exist December of 2007. So the assignments that were filed by Fine Such and Crane showing option 1 as a signer or assignee after that date are void. These assignments are dated April 28, 2008, after the first foreclosure action, June 29, 2011, April 25, 2013, and then there's the C. Indy Mac FSB versus Mendel Measles. And they're talking about how if a bank doesn't exist, it can't assign anything, basically. Okay, so the note and the longes that Wells Fargo fabricated are also fatally defective. The note was blank and the longes not attached. Wells Fargo may claim the note is certified to be a true and correct copy of the original, however, because the last page of the consolidated adjustable rate note bears no endorsements, it cannot be used to prove ownership. To bring a foreclosure action in New York, plaintiffs must own both a mortgage and note at the inception of the action. And then we have some case law explaining standing here. Lots of good case law. Alright, and we'll go down here to the next section. Plaintiff Wells Fargo should be sanctioned. Plaintiff should be sanctioned for both the meritless filing of the complaint, and as a result, Defendant Carrington should be awarded the costs and legal fees associated with this motion. Conduct during the litigation from 2008 to 2023 included the commencement of litigation, is frivolous and subject to sanction and or the award of costs when it is completely without merit of law and cannot be supported by reasonable argument for the extension, modification, or reversal of existing law. It is undertaken primarily to delay or prolong the resolution of litigation or to harass or maliciously injure someone. Okay, so we have some more case law here. Talking about the plaintiff has to have prima facie evidence to foreclose. And then we talk about the appellate court's decision, how they agreed with Carrington and they didn't have standing, and it was reversed. So here let's talk about the conclusion. Based on the foregoing, the plaintiff, Wells Fargo, committed judicial malfeasance in violating the New York Real Properties Act's laws 1301, 1304, and CPLR 3126 by refusing to comply with discovery requests and disobeying the judge's orders. Through its various agents, its servicer, attorneys in fact, attorneys at law, misrepresented that Wells Fargo had standing to foreclose. The fabricated assignments, unattached allonges, and defective affidavit by Daniel Despeche are additional reasons why Wells Fargo and its attorneys should be sanctioned for their misconduct. Carrington was harmed by over 15 years of active litigation, which was costly, destroying his marriage and credit score by forcing the defendant to file bankruptcy to stop the sale. As a result of the defendant's appeal, the appellate court reversed the case, vacating the bank's summary judgment and granting the defendant costs. The reason was the bank's lack of standing. Wherefore, the defendant demands the court to dismiss this case with prejudice, grant relief to the defendant for costs, which was already awarded by the appellate court, and attorney's fees, release the lien in acris, and sanction the plaintiff for $10,000 for their frivolous misconduct. Okay, so that was how this ends here. He also has an the affidavit of service is like a certificate of service. Exhibits, you gotta have the exhibits, and then he also has a affidavit, sworn affidavit in support of motion to dismiss. And he just basically, these are all facts that he put in his, basically supporting his motion. And it's always good to have a sworn affidavit with anything you put in. It gives your stuff more weight. So I hope, if you guys have any questions or you want to read any of this, just send me a request. I can send you a copy of it if you want to read it. If you're trying to file your own motion to dismiss and you have questions, you can send me a text message. Okay guys, thanks for watching, and don't forget to subscribe. And I'll talk to y'all later. Have a wonderful night.